Hello world, today's June 26th, 2024. My name is Chili DeCastro. I am a journalist. I've been unjustly locked up in the Clark County Detention Center for obstruction when I was filming a cop. The kangaroo court, led by Judge Ann Zimmerman, will have to pay when I file my federal civil rights lawsuit when I get out of this dungeon. If you're new to my channel, I'm a First Amendment auditor and I film the police. That's what I do for a living. I've filmed hundreds of cops in my lifetime. The only place I've ever been arrested for filming a cop is in Las Vegas, Nevada. Now, what's happened so far is we filed an appeal. The district attorney has filed their reply. This is the reply to their reply, and the hearing for my appeal is July 10th, 2024. We are now 14 days away. So here's the reply. Start on page 1 here. You can follow along on the screen. Comes now Appellant Jose DeCastro. My legal name is Jose. Through his attorney of record, Chris Orm, this brief is made, and here we go. Page 2. Arguments. Mr. DeCastro's conviction must be reversed based upon violations of the First Amendment of the United States. 1. In this case, DeCastro began filming police interaction from 10 feet or more. It's to be noted that in the DA's reply to the original appeal, he said I was within 5 to 10 feet. Mr. District Attorney, I have filmed hundreds of cops. I always stay 10 feet away. The police interaction occurred in broad daylight where DeCastro complied with the officer's demands to back up. DeCastro utilized provocative and challenging speech while demanding the officer issue a citation to the driver. All of Mr. DeCastro's actions were clearly protected by federal case law and the United States Constitution. The state acknowledges that DeCastro has a constitutional right to film the police interaction. However, the state argues that there are reasonable time, place, and manner restrictions associated with the First Amendment, a point which Mr. DeCastro concurs. Despite this agreement, the state maintains that DeCastro's actions somehow obstructed the officer. First, at trial and on appeal, the state repeatedly contends that DeCastro refused to back up. The state advances this argument to demonstrate that DeCastro hindered and obstructed the officer from completing his duties based on DeCastro's refusal. At trial, Bork testified he did not back up. The officer also testified that there was a 21-foot rule. In closing arguments, the prosecutor argued that DeCastro violated this imaginary 21-foot rule. The prosecutor also argued that DeCastro would not back up when ordered to do so. Page 3. On appeal, the state explained, the difference here is that the appellant was actively interfering and obstructing the police investigation by approaching the driver and refusing to back up. So the officer could not safely conduct his investigation. No matter how many times the state claims that DeCastro did not back up, the video evidence and exhibits belie this claim. A reviewing court can simply view the video and steal photos and observe that Mr. DeCastro complies with the officer's command by stepping back. This fact alone demonstrates the state's insufficiency of the charge. Why would the state continuously make a claim that is contradicted by video and still photos? The United States Supreme Court has condemned prosecutors for obtaining convictions based on false testimony, Napu versus Illinois. Even firmly established Supreme Court case law has not deterred the state from advancing a false narrative. You can clearly see in the exhibits, which I was standing here, I'm standing inside of the white stripe of the parking structure, and then I go 4 feet back from the white stripe from the parking space structure. And then it keeps going. Notably on appeal, the state has abandoned this imaginary 21-foot rule because there is no 21-foot rule. It doesn't exist. At trial, both the cop and the prosecutor argued a 21-foot rule exists, and the worst part about it is that the judge said, oh, there is some 21-foot rule. We objected. It didn't matter. However, the state does not dispute the legal rationale enunciated in Glick versus Cuniff, where the United States Court of Appeals for the Third Circuit addressed the excessive force allegation by making a plaintiff who was filming from 10 feet away. In this case, the officer admitted that Mr. DeCastro was 10 feet away while filming him. The Glick case provides relevant guidance here. In Glick, the court affirmed that citizens have a right to film police activity and noted the plaintiff was 10 feet away from the police. Here, Mr. DeCastro was also 10 feet away and followed the officer's command to back up. The state is openly violating the Constitution by continuously ignoring the case law and presenting a false narrative. That Mr. DeCastro refused to back up and enforce an imaginary 21-foot rule. The state assertions are entirely defeated by the video evidence and uncontradicted federal law. This is the reason why I didn't get a super high-end lawyer. Because I believed that because it was on video, the prosecutor and judge would follow their fiduciary duty and say, well, he did what he was supposed to do. But that's not what happened here. We'll talk more about that later. Let's keep going. Letter A, case cited by the state. In their brief, the state cites numerous cases which all assist Mr. DeCastro. The state cites numerous cases regarding the First Amendment based on reasonable time, place, and manner restrictions. In a footnote, the state appears to take offense to DeCastro's reliance on the George Floyd case. The state appears to argue that the reliance on the Floyd case is misplaced. However, the state also cites Fields versus City of Philadelphia for the proposition that the First Amendment encompasses the public right to access government information. Actually, the case cited by the state establishes exactly why Mr. DeCastro relied on the Floyd decision. In Fields, the U.S. Court of Appeals for the Third Circuit considered the case of a watchdog group that was filming police at a protest in the Philadelphia Convention. Ironically, the Fields Court utilized the exact same reasoning as Mr. DeCastro. It read this in the Fields' opinion. In 1991, George Holliday was recording video of the Los Angeles Police Department officers beating Rodney King and submitted to the local news. Filming police on the job was rare, but common now. With advances in technology and the widespread ownership of smartphones, civilians' recording of police officers is ubiquitous. These recordings have both exposed police misconduct and exonerated officers from errant charges. However, despite the growing frequency of private citizens recording police activity, and it's important to all involved, some jurisdictions have attempted to regulate the extent of this practice. Individuals making recordings have also faced retaliation by officers, such as arrests on false criminal charges and even violence. This case involves retaliation, as does mine. Officer Bork lost his mind. His face was beet red. He was so mad I was there filming him, and I called him a little dog. You're going to hear that in a second. Continuing in the bottom of page 4. In essence, the Federal Court of Appeals for the Third Circuit, when considering the retaliatory nature of police departments arresting private citizens for filming, began their legal analysis by citing an incident on the other side of the country, wherein a private citizen was recording the beating of Rodney King. The Fields case, which was decided in 2017, 3 years before George Floyd's killing. Mr. DeCastro embarked upon the same legal analysis cited by the George Floyd case. The state scoured the United States case law and located a case that entirely supports DeCastro's claim. The appellate court must wonder whether the state even read the Fields decision before citing it and complaining about DeCastro's reliance on the George Floyd case. Next, the state cites Smith versus City of Cummings, which establishes a First Amendment right to videotape and photograph police conduct. The state cites Turner versus Driver, which is in your trifold and also on the cop card, where the U.S. Court of Appeals for the Fifth Circuit reversed the lower court's decision to provide qualified immunity for 2 cops for an unlawful arrest in the violation of the Fourth Amendment, based upon an arrest for filming a police station. Nothing in these cases supports the state's position. Instead, they further bootstrap Mr. DeCastro's position. Moreover, the state relies on Askins versus U.S. Department of Homeland Security. In Askins, the court considered the filming by private citizens of a United States port of entry on the Mexico border. Ultimately, the Ninth Circuit remanded the case based upon the district's court's dismissal of the plaintiff's First Amendment claim that the plaintiff was wrongfully arrested for filming. How does this advance the state's case? It doesn't. So when you go on LexisNexis, if you're an attorney, you can put in there time, place, and manner, First Amendment, and it will spit out a bunch of cases for you. That's what the district attorney did. And what my lawyer did, Chris Orem, he went and read every single one of the cases and said, all of these cases work in our favor. And that's what he's pointing out here. And then in the next case, this is great. And here's what Orem does just beautifully in this one. Bottom of page 5, last paragraph. Finally, the state relies upon ACLU versus Alvarez for the proposition that the police may take reasonable steps to maintain safety and control of a crime scene. The case involved the prosecution of an individual who was recording police under a retaliatory eavesdropping statute. The Alvarez court reasoned on the merit of the state's attorney has staked out an extreme position. She contends that openly recording what police officers say while performing their duties in a traditional public forum, street sidewalks, plazas, and parks, is wholly unprotected by the First Amendment. This is an extraordinary argument. Again, the state's reliance upon the numerous cases cited in their brief either significantly assists DeCastro or is misplaced. Comically, the state claims DeCastro is attempting to create his own standard by testifying that he backed up a couple of feet in response to the officer's commands, and that he did not physically interfere with the officer. However, it is worth noting that filming from a distance of 10 feet away from an officer has been upheld as constitutionally permissible in the Glick decision cited by the state. In reality, it is the state that has fabricated its own arbitrary and shifting standards. At times, the state vehemently denies that De Castro backs up and instead provides their own imaginary standard of involving a 21-foot rule that's unsupported. It is the state that's creating their own unconstitutional standard in direct violation of clearly established federal case law. So let's talk about these two paragraphs on page 6. Comically, the state has claimed that Mr. De Castro is attempting to create his own standard. I'm going by a standard created in the case called Glick versus Cuniff. I know exactly what I'm doing. When I tell the cops I'm not moving my feet, that's because I'm more than 10 feet away, and I know it for a fact. You guys have seen me do it dozens of times. And I explained to them I did back up a couple feet just to make sure I was at least 10 feet away. I'm explaining to them that I'm following constitutional case law outlined by the District Court, Circuit Court, or Supreme Court of America. Back down to paragraph number 3 on page 6. The state repeatedly argued time, place, and manner for restrictions throughout their brief. However, when Mr. De Castro recorded this interaction, it was in broad daylight in a safe area of a large parking lot during a traffic stop in which De Castro approached the officer and the woman in the vehicle and openly identifies himself as a member of the press. Why is De Castro's recording of a routine traffic stop considered inappropriate in terms of time, place, or manner? What alternative time, place, or manner could De Castro have chosen to record this interaction more appropriately? And this goes to Orum's basic argument. If the cop had been choking and killing the woman, then I would be a hero. But because it was just a routine traffic stop, then they criminalized me and they put me in jail. The United States Constitution and federal case law unequivocally affirms the right of citizens to film police. The images of citizens filming the murder of George Floyd in close proximity to the officers serves as a definitive evidence of this right. Notably, the individuals who heckled and filmed the officers in the George Floyd murder were closer to the officers than Mr. De Castro was in this case. The Federal Court of Appeals for the Third Circuit acknowledged that the citizen who filmed Rodney King beating played a significant role in shaping considerations related to the filming of Philadelphia police decades later. Even a cursory review of the body cam footage clearly demonstrates that when Mr. De Castro used provocative and challenging language, the officer became enraged and moved towards Mr. De Castro, not because he was frightened, but because he was insulted. He then grabs De Castro in an aggressive manner, which ultimately will be problematic for the officer in federal court. You bet it will. Officer Bork is being sued in federal court, as is Sandoval, and as is the supervisor. I'm suing all of them, and they're going to lose. They had no right to do this. I should not be in jail. In our society, police officers are expected to endure significant burdens caused by citizens who exercise their First Amendment right. See Houston versus Hill. Houston versus Hill is on your trifold and on your cop card. Unfortunately, the officer was unable to control his behavior in the face of provocative and challenging speech. Mr. De Castro's convictions must be overturned based upon a violation of the First, Fourth, and 14th Amendment to the United States Constitution. Number 2, there's 4 arguments that Orum is putting forward, and this is the second argument, bottom of page 7. Count 1 and 2 must be dismissed because NRS Code 197.190 and NRS Code 199.280.3 are void due to being unconstitutionally vague and ambiguous. I'm going to refer to these simply as obstruction when they come up here and resisting. I'm not going to say the codes every time. I'm just going to say obstruction for 197 and resisting for 199. Obstruction and resisting are constitutionally vague and ambiguous as applied to Mr. De Castro's case. De Castro did not intentionally hinder or obstruct the officer from issuing a citation to the driver. Additionally, De Castro did not resist arrest as he was unlawfully arrested. At trial, the officer was unable to articulate how De Castro's behavior obstructed his ability to complete his duties. The officer simply testified, "Again, I don't know what his intention is. I don't know if he's armed. All I saw him was recording, which again I had no issue with. I told him I didn't have an issue with." Not only did De Castro not attempt to hinder the officer, he instructed the officer to go get in your car, little doggy, and write your ticket. Mr. De Castro was convicted of attempting to obstruct the officer despite the fact that he actually told the officer to write a ticket. Remember, you have to intentionally go there, willingly trying to hinder or obstruct the officer to be charged with obstruction. Second paragraph down, page 8. Again, the state cites cases that further bolster Mr. DeCastro's arguments. For instance, the state cites Stubbs versus Las Vegas Metro Police Department. In Stubbs, an attorney decided it would be advisable to stand next to his biker client while the police were attempting an arrest. Stubbs was repeatedly told to step away from the client during the stop. Stubbs argued he had a right as the attorney to stand shoulder to shoulder with his client during the traffic stop while armed. The Ninth Circuit determined there was probable cause for the arrest of the attorney. Mr. DeCastro agrees with the Ninth Circuit decision. An attorney does not have a right to stand shoulder to shoulder with his client during an arrest while armed, ignoring repeated commands of the police. Stubbs is completely distinguishable from this case. In other words, the Stubbs case, you could not apply it to my case because I didn't try to go stand shoulder to shoulder with another person while I was carrying a gun. On February 22nd, 2024, the Nevada Court of Appeals examined obstruction in Wilson versus First Judicial Court of Nevada. The court determined that specific intent to hinder, delay, or obstruct is a requirement of the statute. Let me say this again. On February 22nd, the Nevada Court of Appeals examined obstruction, NRS Code 197.190. The court determined that specific intent. I'm a First Amendment auditor. My intent is to film what the cop is doing. That is my intent. My intent is not to hinder, delay, or obstruct. And it said the court determined that specific intent to hinder, delay, or obstruct is a requirement of the statute. The court further held, therefore we interpret obstruction as applying only to physical conduct and fighting words. The court further explained that blocking the path of an officer may amount to obstruction. The court cited Washington versus Hudson, where non-aggressive behavior may cause obstruction. In Hudson, the court found obstruction where the defendant was stopped while driving and proceeded to flee from police officers who had drawn their weapons. So, in other words, what this says right here is that the district attorney is citing a case called Washington versus Hudson and saying that this case applies to my case. Okay, and what Orem is saying is, hold on a minute. You mean when he was pulled over and then ran from the cops? It's completely distinguishable. They're two different cases. Mr. DeCastro agrees that fleeing from a lawful traffic stop amounts to hindering and obstruction. I love page 9 here because this really kind of wraps into a nice little present. In Wilson, the court reasoned, as construed by this court, obstruction prohibits only physical conduct and fighting words that hinder, delay, or obstruct a public officer in the discharge of official duties or powers. As such, law enforcement has no discretion to arrest persons for protected speech or for physical conduct that is merely annoying or offensive. In Wilson, the court determined that the real issue was whether there was sufficient evidence to convict Wilson of the obstruction charge and whether the district court had properly considered the issue on appeal. The appeals court explains this right here. The district court did not have the benefit of our interpretation of obstructing, NRS 197.190, as being limited to physical conduct and fighting words, and it therefore did not consider whether there was sufficient evidence that Wilson engaged in physical conduct or uttered fighting words so as to support her conviction of violation of obstruction. The court remanded the case for the district court to properly review the issue considering the ruling. The Wilson decision was filed less than a month before DeCastro's trial. This court should consider the rationale enunciated by the Wilson court in determining the sufficiency of the evidence to convict and whether the statute was constitutionally as applied to DeCastro. In other words, they're saying that the Nevada Supreme Court has already said that obstruction means it's a physical act, as I told the cop on the scene. Last paragraph, page 9. Mr. DeCastro was never seen physically attempting to obstruct the officer. Additional, although his words may be considered provocative or challenging, and Orem likes to use the word annoying, but I don't think it was annoying. I think my words were provocative and challenging. Both state and federal courts have identified that the language Mr. DeCastro used is protective. Mr. DeCastro invited the officer to write a ticket, which is the opposite of obstruction and hindering. This is simply a case of an officer who became enraged and retaliated against Mr. DeCastro. He's going to have big problems with a federal civil rights lawsuit. Mr. DeCastro never resisted a lawful arrest. The officer inexplicably grabbed him in anger, not the other way around. This was an unconstitutional and unlawful arrest. Mr. DeCastro never willingly resisted the police officer from attempting to discharge his legal duty. The officer was acting unconstitutionally and unlawfully. In fact, Mr. DeCastro requested the officer contact his supervisor based on Mr. DeCastro's belief, and I knew that the officer was acting in an unlawful and unconstitutional manner. Therefore, both statutes are unconstitutionally vague and ambiguous as applied to DeCastro. Number 3, and this is where we get into the judge. And this is limited because in my federal civil rights lawsuit against this judge, I'll go much more into detail, but number 3 says here, Mr. DeCastro was denied his state and federal constitutional rights when his trial was presided over by a judge with a prejudice against Mr. DeCastro and a bias in favor of Metro and the state. During the trial proceedings, the trial judge demonstrated a bias against DeCastro. First, the trial begins with the court announcing the court is the judge, that Mr. DeCastro would have to empty his pockets and give up your phones, and stated, "Yep, I really don't want to be a part of your YouTube channel." Defense counsel was ordered to turn off his phone. So just so you know here, when the judge said, "Yep, I really don't want to be a part of your YouTube channel," my YouTube video was never submitted to the judge. The only videos that the judge saw were the cops' body cam footage. That means that she had to personally go to my YouTube channel and watch it. In answering brief, the state argues that the filming of the court proceedings is governed by the Nevada State Supreme Court rules. The state claims that the court was simply ensuring that no one else was going to film without the court's permission. However, conspicuously absent from the state's analysis is the court's failure to demand that the prosecutor turn off her cell phone or surrender her cell phone to the marshal. Evidently, Mr. DeCastro and his attorney were singled out in this directive. The court did not enforce a universal prohibition on recording. Rather, the court directed the requirement exclusively to DeCastro and his attorney. Here, the court was clearly singling out Mr. DeCastro and his lawyer. The state's position, if applied, violates the Equal Protection Clause of the 14th Amendment of the United States Constitution. Top of page 11, this is where Orem really breaks down a couple things, and I will go over it paragraph by paragraph. Mr. DeCastro will rely upon the case law cited in his opening brief regarding implied bias with one exception. The state recognizes a judge may disqualify herself from acting in any manner upon the ground of factual or implied bias. However, the state correctly notes that Mr. DeCastro's attorney did not request disqualification. First, DeCastro agrees with the state that this was yet another example of the failure of counsel to effectively represent DeCastro. However, the failure to object is not fatal to the issue. In other words, it's not a fatal error that my lawyer did not object, because it can be overcome. She should have recused herself. The moment she was going to my YouTube channel and watching it, she should have recused herself. However, the failure to object is not fatal to the issue. Echevarria versus Filson, the court reversed the capital murder conviction of the petitioner who had been convicted of the murder of an FBI agent in Los Angeles. The Ninth Circuit noted that the Nevada State Supreme Court had made the decision based on whether the trial judge was subjectively biased. The court also noted the Nevada State Supreme Court had a similar mistake in Rippo versus Baker. The appropriate question is whether the average judge in that position is likely to be neutral or whether there is an unconstitutional potential for bias. In Echevarria versus Filson, the Ninth Circuit reiterated that the test for judicial bias requires only showing an undue risk of bias based upon psychological temptations affecting an average judge. So right there, let me say this again. The Ninth Circuit reiterated that the test for judicial bias requires only a showing of undue risk of bias based upon psychological temptations affecting the average judge. We'll go to the very beginning of the trial. The judge says, "I'm not going to be a part of your YouTube channel." Obviously, she was psychologically affected by the cameras being in the courtroom. This is why no judge in America wants cameras in the court. Very few. There might be some, but there are very few because it psychologically affects them when the public watches what these judges are doing. And this judge is going to have big problems when I sue her. She's going to be held accountable. The Ninth Circuit noted that a showing of a constitutionally intolerable risk of bias does not require proof of actual bias. The Ninth Circuit noted that a showing of a constitutionally intolerable risk of bias does not require proof of actual bias. See Williams versus Pennsylvania. Neither Mr. Echevarria nor his co-defendant, Carlos Scurry, originally objected to the trial judge. However, both defendants were permitted new trials based upon the implied bias. Mr. Gurry's conviction was reversed by the district court and the ruling upheld by the Nevada Supreme Court in an unpublished opinion. Here, Judge Ann Zimmerman was clearly biased against Mr. DeCastro, as is established in the facts enunciated in the opening brief and in this reply. The trial judge should have recused herself sua sponte. In other words, she should have said, you know what, I went to his YouTube channel and I watched a bunch of his videos and I've decided that he hates cops, so I'm going to recuse myself. Because she was married to a cop for over a decade. So she should have recused herself, but she didn't. Point 4. Mr. DeCastro received ineffective assistance of counsel. DeCastro received ineffective assistance of counsel pursuant to the 6th and 14th Amendment of the United States Constitution. Mr. DeCastro would rely upon legal standards of ineffective assistance of counsel enunciated in his opening brief in the state's brief. The Nevada State Supreme Court has held, we have generally declined to address claims of ineffective counsel on direct appeal unless there has already been an evidentiary hearing or where an evidentiary hearing would be necessary. Pellegrini v. State. In this case, ineffective assistance of counsel can be established without the need for an evidentiary hearing. Trial counsel failed to file pretrial motions addressing the First Amendment issue litigated in this appeal. Counsel further failed to file a motion regarding the statutes utilized to convict Mr. DeCastro in this case. Additionally, counsel also failed to argue judicial bias. This lays out what my attorney failed to do. DeCastro's lawyer failed to file a pretrial motion addressing the First Amendment issues. He didn't file a brief that said, here's the First Amendment issues. You have Glick versus Cunniff. You have Turner versus Driver. The cases that the state cited in their rebuttal are the cases that he should have submitted to begin with. Counsel further failed to file a motion regarding the statutes utilized to convict Mr. DeCastro in this case, that the statute 197.190 was unconstitutionally vague and ambiguous as applied to me. Additionally, counsel also failed to argue judicial bias. The moment that judge had me searched, the moment she screamed out loud, she's not going to be a part of my YouTube channel, my lawyer should have stood up and said, I need you to declare a mistrial. Obviously, you're biased. But he didn't do that. In their answering brief, the state asserted that the trial counsel filed a bench memorandum citing relevant case law concerning the First Amendment claim. He did the day before trial. However, the state neglected to mention that the memo was filed untimely. The trial judge noted that she never received a copy of the memo, and the prosecutor requested that the motion be stricken, and it was. Consequently, the court did not consider the memorandum, and Mr. DeCastro was promptly found guilty following the discussion about the memo. Now on appeal, the state argues DeCastro received effective counsel, even though the prosecutor and the court found the memo untimely and moved to strike it, and they did. Had counsel properly litigated the issues before and during the trial, the result at trial would have been different. As indicated in Wilson, the Nevada Court of Appeals explained that the district court did not have the benefit of their decision. The Nevada Court of Appeals they're talking about is the Nevada State Supreme Court. Moreover, in the present case, the trial judge was not informed of the Wilson decision, which was rendered 30 days of the trial. The trial judge should have had the opportunity, as this court does now, to have the issue thoroughly and properly litigated in its entirety. Therefore, reversal is mandated based upon the First, Fourth, Fifth, Sixth, and 14th Amendment of the United States Constitution. Conclusion. Wherefore, based upon and above foregoing, Mr. DeCastro respectfully requests that the court reverse his conviction. This date, June 18th, 2024. Now, this is going to be heard July 10th in front of Michelle Levitt in the district court. I feel like this reply definitely lays out every single point. See, I was standing here at one point. The cop asked me to back up. I backed up at least 4 feet. Now I was 14 feet away. At least 14 feet away, because I know how far 10 feet is. I've measured it 20 times, at least more, to make sure that I stay 10 feet away from coppers when I film them. Typically what I do is I position myself maybe about 14, 15 feet away, so that the cop will walk up to me and say, hey, can you move over there so I can tell him squarely in his face? No, I'm not going to move my feet. You guys have seen me do it dozens of times. That's because I know the case of Glick versus Cunniff. I know it backwards and forwards. I've studied it. I know what the limitations are. I know what my rights are. I just think it's absolutely hilarious that the state creates this magical 21-foot rule that they don't continue to argue, that they convicted me on, a magical 21-foot rule that does not exist. Then on page 6 here of the brief, it says, comically, the state claims that Mr. DeCastro is attempting to create his own standard. I'm going by the standards that are laid out by the court, Glick versus Cunniff. And then the next paragraph down, it says, in reality, the state has fabricated its own arbitrary and shifting standard. That first, I didn't back up, and then second, that there's some magical 21-foot rule. It doesn't exist. It's not real. Had I not had a judge who clearly was biased, now I've been in this frickin' dungeon for over 3 months. And let me tell you something. It's been absolute hell. You know, it's as though the idea of this jail is that you're being punished. And the folks who work here, about half of them, believe that it's their job to punish you day in and day out. It's jail. You're not supposed to like it. Things like that. I've heard that dozens and dozens of times. So you guys have now the reply brief. The hearing will be July 10th, 2024 here in Clark County. If you guys want to come, you can. And I'm going to make sure that my people are not banned at the door. So reading this, it's just kind of, it's almost like drinking bitter beer. You read this and you go, ooh, it just makes you cringe. The fact that they created some imaginary 21-foot rule, and that they said that I was creating my own standards when I was following the exact standards created by the court. Just a quick shout out. Thanks you guys for your support. I appreciate it. I really do. There's been a lot of things going on that I can't talk about right now. I'll talk about it when I get out of here. So today, by the time you hear this, it'll be June 26th, 2024. 14 days away from the appeal. I should be released from this dungeon on July 11th, 2024. All right, I'll let you guys go. Thank you for your time. I really appreciate your support. So many of you guys have supported me. If you want to support me further, you can go to this secureustech.net and you can put $5 or $10 on my books for this phone because they charge you 16 to 18 cents a minute. secureustech.net. My inmate number is 1669561. Just $5 or $10, and if enough of you do it, then it'll be enough where I can keep making phone calls while I'm locked in this dungeon. This has been absolute hell. I can't. I wish that I could say. I was talking to another auditor on the phone the other day, and I said to him, I wish that I could say that this has been easy, and I've just gotten through this, and I've just slid right by, and it's been no problem. But that's not true. It has been extraordinarily difficult, and it's difficult every day, every single day, from the time I wake up till the time I go to sleep. I relish when I get to go to sleep. When I get to go to sleep, sometimes I get to go to dreams, and they make the world a better place for me. Sometimes when I go to dreams, I'm right back in jail again. And it's worse. It's a darker dystopia than I'm living in now. So, with that being said, I'll let the editor get to work on this cut for my journalistic update for the day. Thank you so much for your support. We are Team DLZ. We don't stop. We don't quit. And we'll see if we can get around the judge's judicial immunity when I sue her federally for what she's done, and the cop federally for what he did. I'm losing my voice. I gotta get this walk out of here. Thanks for coming. I'll see you guys on the next one. Later, Gators.